Redress was founded 20 years ago, and I'm delighted as we come to that anniversary that Chatham House is hosting this event this evening. I want to welcome Keith Carmichael, who founded Redress, and did so because there needed to be an organization to support the survivors of torture. Redress has moved on to do that in a whole range of different ways across a multitude of countries, and we also try to campaign vociferously against torture. Why is that? Well, it's very simple. The torture is illegal in customary international law, illegal on 193 countries of the United Nations. Torture is immoral, and it just doesn't work. And the existence of torture demeans all of us, not just the perpetrators, but it demeans societies that permit it to happen. And the paradox is that it's all too prevalent. That's why the work of the United Nations is so important. But it's often carried out by states who claim to be the highest defenders of rights, and yet they resort to it on what I think is a wholly false basis. The United Nations is in the vanguard against torture, supporting the rights of victims, standing up for those who perpetrate crimes against humanity, of which manifestly torture is one. Prominent in the United Nations system is Professor Juan Mendez, a distinguished servant of the international community and the United Nations Special Rapporteur on torture. He has worked conscientiously, diligently in this field for a very long time, has done so with great distinction. So my great privilege tonight is to welcome you, Professor Mendez, and to now invite you to address the Chatham House audience. Thank you. Thank you.
Thank you all for being here today. I especially want to express my appreciation to Redress, and to its director, Carla Firstman, and to Sir Emyr Jones Parry for inviting me for this very special occasion. I think I want to congratulate Redress on so many years of excellent work on behalf of human rights and particularly on enforcing the prohibition on torture. It is an honor to share in the celebration of the many achievements of Redress, and it is an honor also for me to be back, because I was here once some years ago, in Chatham House, because you know better than I that around the world this is a place where very serious discussions are held over matters of great importance to the interdependent world in which we all live. I also want to commend Redress for having the idea of focusing on the implementation of the prohibition on torture for this occasion. Among other things, I think one of the challenges that the rapporteurship faces in this term that I started a year and a half ago is that I feel that in the last 10 years or so, we have lost, or at least temporarily lost, an important asset that we have in the fight against torture, which is the moral condemnation that people generally have always agreed upon on the abject nature of torture. I think in the last 10 years, the culture has, and not in a single country, in many countries around the world, has generated a sense of, well, perhaps torture is inevitable, or perhaps torture is bad, but it's necessary because it keeps us safe, it moves us in the direction of curbing criminality, and particularly the most extreme forms like terrorism, and therefore somehow I think our societies have tended to look the other way. They don't necessarily accept torture can be moral or even practical, but there's a sort of resignation that torture is inevitable. And I think that is an important factor in our ability to find ways of abolishing torture in our time, which I think is still possible, not necessarily likely, not necessarily assured, or certainly not assured, but possible. Just like humanity ended slavery 100 years ago or so or more, I think eventually we can come to a point where we can say that torture is not only prohibited but effectively abolished. But I feel that we need to get back to persuading our societies that that this is what needs to happen. So I start with recalling some of the principles that are in the Convention Against Torture, but as Ambassador Jones Parry very correctly stated, these are principles that are customary international law, that widely recognized as applying and obliging all member states of the United Nations and all member states of the international community generally. So torture is absolutely prohibited, and it doesn't recognize any excuse because of states of emergency or any other excuse, not even any excuse based on some form of exceptionalism of the situation or of the nation that indulges in the practice of torture. And the prohibition also extends to cruel, inhuman, and degrading treatment or punishment. Because as you know, the Convention distinguishes between torture and cruel, inhuman, and degrading treatment on a variety of bases, but certainly not for the absolute prohibition of their practice. So any coercion that does not meet the definition of torture because it's not as severe to reach that definition, or because it lacks the requisite intent to elicit a confession or a declaration, is still prohibited absolutely by international law. So I think, in fact, no country in the world rejects that proposition. There's no country in the world that affirms that torture or even cruel, inhuman, and degrading treatment is permissible. And that perhaps is a good starting point, because even the countries that do practice torture recognize its prohibition and try to call it something else, or simply deny that it happens, and then they surround the practice with layers of impunity that that are intended at least to establish a sort of plausible deniability that the practice exists. And I think the infamous torture memos written in the Bush administration during the Bush administration are, paradoxically a recognition of this, because if you read them carefully, they describe a variety of techniques and try to say that they don't constitute torture. Disingenuously not saying, for example, as if they are applied in a degree of intensity and severity, they do become torture, or that they're applied in combination between them to the same victim, they also become torture. And that, quite frankly, anybody who reads about waterboarding, about stress positions, etc., would not come to the conclusion that it's not torture. But what I think is particularly negative and dangerous of the torture memos is that because they're meant to determine when somebody should or could be prosecuted, they don't say that those things may not be torture, but even in an individual basis and taken one at a time, they would unmistakably constitute cruel, inhuman, and degrading treatment, and therefore would be prohibited anyway. The torture memos, kind of skirt around that issue and don't say that they're actually encouraging United States officials to engage in unlawful activity. The problem is, and of course there are many other examples, but the problem is that these kinds of arguments take advantage of what I consider some ambiguities in the definition of torture, because to reach the level of the definition of torture, the pain and suffering has to reach a level of severity that depends both on objective and on subjective factors. And so it's very difficult to trace a line and say, this practice is cruel, inhuman, and degrading, this other practice is torture. Nevertheless, I think if states understood their obligations in good faith, even that ambiguity should not offer all that problems. We have to be reminded that the definition includes pain and suffering that's either mental or physical. For the most part, physical torture is accompanied by mental torture as well, as anybody would realize. It's the fact itself of the inhumanity of the treatment that is also degrading by itself. It's demeaning by itself. And it's premised on an attitude of not recognizing the humanity of the victim. And therefore, it's automatically psychological as well as physical torture. But the requirement that that torture be inflicted with the specific purpose established in the Convention Against Torture sometimes conspires against being able to find good ways of curbing the practice. But my mandate, and of course it's based on the Convention Against Torture, includes all other forms of cruel, inhuman, and degrading treatment, and particularly, I would say, when certain prison conditions reach a level of pain and suffering in the persons held there, that does not have to be intentional and does not have to be as intense as to qualify as torture. Nevertheless, the prohibition on cruel, inhuman, and degrading treatment is obtained anyway, and therefore my mandate spends a lot of time, quite frankly, dealing with prison conditions and how to make them better. I think the second important legal effect of the prohibition against torture is the obligation to investigate, prosecute, and punish every act of torture. And here, torture, among all other human rights violations, is unique in international law because a single event gives rise to the obligation to investigate, prosecute, and punish. It doesn't have to be part of a widespread and systematic practice, which of course would then make torture a crime against humanity and subject to the jurisdiction in the appropriate cases of the International Criminal Court. But although other human rights violations may be subject to amnesties or pardons, or even statutes of limitations, in my mind and in the work of the Special Rapporteurship, we always insist that if there is an affirmative obligation to investigate, prosecute, and punish every act of torture, then there is also a prohibition on using of any legal obstacles to realize that obligation, including amnesties, pardons, prosecutorial decisions not to investigate, and even statutes of limitation. In that sense, I think we were very encouraged in 2009 when President Obama unmistakably prohibited torture, and of course the torture memos had been withdrawn before that by President Bush himself. But reinstated the code of military justice that actually includes the same prohibitions as international law. But unfortunately, I have to say that the decision not to investigate, prosecute, and punish what happened when those torture memos were in effect is a refusal to accept an obligation in international law that the United States has. And unfortunately, there's been no serious investigation, and recently the only investigation that was still going on by Special Prosecutor Durham was completely terminated with a decision not to prosecute even cases in which the torture victims had died and that had happened even before the torture memos were written. So there was not the excuse that people might have been following advice that may be wrong, but they were in good faith following advice. So it's a very disappointing position, because you can imagine how hard it is for the Special Rapporteur on Torture to go around the world saying you have to investigate, prosecute, and punish, when the first reaction is, well, if the United States doesn't do it, why should we, right? And it's important to say that perhaps the prohibition on torture by President Obama is still holding. I wish it was so easy, because torture happened even when it was part of policy of the U.S. administration, so much in secrecy that it's very hard to know whether, in fact, there are new cases or not. It may be that they're being more careful with the evidence, or it may be that, in fact, President Obama is right, and they've turned a new leaf and are not practicing torture now. But it's impossible to know with any degree of certainty. What one can say with some degree of certainty from the examples of other countries is that the impunity itself is a breeding ground for new cases of torture, and therefore, leaving aside the legal obligation to investigate, the practical aspects of not investigating could be damaging for the future as well. I think the international law also mandates that states should afford an effective remedy and reparations to the victims of torture. That means that states are obligated to give full effect to the writ of habeas corpus, because the writ of habeas corpus doesn't protect individuals only against arbitrary arrest, but also from all kinds of conditions of that arrest that could include torture or cruel, inhuman, and degrading treatment. Obviously, other judicial protections also have to be in place to prevent and stop torture and to control conditions of detention. And unfortunately, in many countries around the world, the writ of habeas corpus has been limited, has been curbed, has been ways have been found to limit its effects, if not to limit its application completely. I think this obligation to provide an effective remedy is hampered sometimes by the extensive use of state secrets. I definitely agree that states have to have secrets, but I would take the view that President Dilma Rousseff of Brazil, about a year ago, when she created a commission a truth commission for the violations that had happened in Brazil during the military dictatorship. And one of the problems that they had there was that they had to amend the statute on state secrets. And she very publicly said, well, there should be no state secrets for human rights violations. That they should not be covered. That's easy to say and difficult to put in practice, I realize that. But I think the fact that state secrets have been used, for example, in a case in the United States dealing with the use of aircraft to conduct extraordinary renditions, where the U.S. government came in. It was not even a defendant. The defendant was an aircraft company. The United States came in and established a very sweeping state secrets defense And unfortunately, the courts in the United States accepted it. And so the victims of torture, of that case at least, were rendered without a remedy, without any possibility of finding out what had actually happened and whether that company had any responsibility for it or not. I think the same could be said when we're talking about the exchange of information and exchange of custody of individuals between countries. As you know, here in Britain, the United Kingdom has taken, so far at least, a position that they call the control principle, that whoever is the original owner of the intelligence determines whether it can be made public or not. That's probably a good way of maintaining good working relationship between intelligence agencies, and that's in itself an important consideration. But when that control principle means that then the country that is in possession of information about human rights violations is not in a position to mention them, I do think that it hampers the ability of dealing effectively with torture. The same I would say again on a third principle or legal effect, the exclusionary rule. Unfortunately, here the international law is very limited because the Convention Against Torture says that states cannot use evidence or statements or declarations obtained under torture in criminal actions against that person. But it doesn't prohibit any other uses of the information that thus obtained, and it says statements and declarations proven to have been taken under torture, which becomes a very vicious circle, because in country after country we find that courts take a very cursory view at the matter. When somebody complains of torture, they say, well, prove it, and they effectively put the burden of proving the torture on the person who has made a confession or a declaration. And in practice, the effect is nullified, because if the idea was to discourage torture by negating legal effects to the information obtained under torture, that doesn't help if the prohibition is taken in such a narrow view. So I have been, as a special rapporteur, proposing a much what I consider a good faith interpretation of the exclusionary rule and of its purpose, that is the discouragement of torture, urging governments to not allow any declaration that is not ratified or stated spontaneously before a judge and with all the guarantees of voluntariness, including legal counsel. Unfortunately, this is a difficult area, because prosecutors and courts around the world are used to dealing with allegations of torture in this very cursory and insufficient manner. But I also believe that a good faith interpretation would make the confession ascertained to have been made under torture excludable, but not only that, but also any other evidence obtained as a result of having obtained that. And that's the doctrine that is sometimes called the fruit of the poisonous tree doctrine. I think, in fact, the rapporteurship does and should continue to promote and propose that states adopt this, again, as a good faith interpretation of the exclusionary rule. And the last important, last important legal effect is the non-refoulement clause, that, as you know, means that states cannot return or send anybody to a place where he or she could be tortured. And it is a much more, it's broader than the non-refoulement clause in the 1951 Convention on Refugees, because it does not exclude even people who may have themselves persecuted others. It also doesn't mean necessarily that people should be entitled to asylum. It just means that they should not be sent back to where they could be tortured. Those are, I think, the four major principles of international law, and for lack of time, I won't be able to get into other aspects that I wanted to cover, but perhaps in the question and answer period, we could discuss a little more how the special rapporteurships do their work. And they're basically by way of communications, receiving complaints from the public and formally addressing states for information and eventually issuing views or conclusions about them. The second is by fact-finding missions. And the third is by special thematic reports that we have the occasion of sending to the General Assembly or to the Human Rights Council twice a year, once a year to each of these organs. And in my case, I have written already about solitary confinement and under what conditions there should be sort of an agreement among states as to how to limit solitary confinement. The second was about commissions of inquiry and how they can be made to be fashioned in a way that fulfills the obligation to investigate, prosecute, and punish. And now I have written one that is not public yet on the death penalty and how capital punishment and under what conditions it violates the prohibitions on cruel, inhuman, and degrading treatment. And hopefully that will be debated in the General Assembly in October. My next thematic report is going to be, kind of going towards the limits of the mandate to situations in which the state agency is not absolutely clear, and dealing with torture in healthcare situations. Meaning by that certain treatment for mental health patients, but also for juveniles in so-called educational settings, denial of pain treatment for some patients, drug treatment, drug addiction treatment, and trying to explore to what extent the state can be responsible for making sure that even in the private areas, cruel, inhuman, and degrading treatment or torture does not happen. I really appreciate your attention, and I'm looking forward to the conversation that we're going to have. Thank you.